Good evening, everyone. We all know that Justice Paramjeet Singh Dhaliwal, a former judge of Punjab and Haryana High Court, who has also remained the State Consumer Commission Punjab as a president. His sessions we have taken on all subjects, but since he has been closely associated with the consumer field, we keep on requesting him. And the most fascinating part is that his flair of communication with English, Punjabi, and Hindi is equally at ease. Today's session, we thought, let's understand that we have always been reading day in and day out to the effect that they are standard form contracts which run into 40-50 pages. Does the signature on that standard form contracts itself would construe that he has abided and agreed to go ahead with the terms and conditions, or thereafter he can challenge? Especially these aspects come arising when there are issues in respect of medical negligence, with the colonizers, and the insurance. To understand this fascinating subject of unfair terms and standard form contracts, and what is the legal aspects, today's session would be focused on that. But stay tuned with us to have the deeper dive of this knowledge through Justice Paramjeet Singh Dhaliwal. Over to you, sir.
Thank you. Good evening to all the viewers. I'm thankful to Mr. Vikas, and off and on he bring me before you for one reason or the other, or some topic which are of recent also necessary for the consumer, specifically builder buyer issues, insurance issues, medical negligence, being a corporate setup now, charging excessive amount in all the transactions. So today we will be dealing with in general, the standard form of contracts. Unfair terms in standard form of contracts, which is the crucial subject and has recently been added in the new Act of Consumer Protection Act 2019, wherein specific provisions have been added. Earlier, there was no such provision in the Consumer Act. This has come into force from 20th of July 2020. And I will try to explain about this concept and its relevancy in consumer contracts, specifically the consumers. But first we will have to understand what is the meaning of standard form contracts. In how many names have been given to this standard form contracts? Standard form contracts are contracts between the two parties where terms and conditions of the contracts are drafted by the one party and are accepted by the other party. These terms are generally non-negotiable and are in favor of the business houses or the builders, whatever you call, insurance companies, banks, etc. The various names given to this standard form contracts are boilerplate contracts, take it and leave it, adhesion contract the adhesion in this is called in France, or leonine contracts also. These are the various names given to the standard form of contracts. When we talk of this, apparently when there is a contract signed between the parties are bound by the terms and condition. Presumption is that this has been framed after negotiation, but the situation in the standard form contracts is altogether different. The potential of unconscionability, because the decisions are in such like contracts which are voluminous in nature, having 40, 50, 100 pages many times. I think when you look into the insurance contract, when you are taking a insurance, life insurance or general insurance, you just sign the few papers and there are ifs and buts and exclusion clauses existing there, which we never read. They are otherwise in also in a fine print, so it becomes necessary how to protect the consumers from these unfair terms and what are the complications they have to face. Law is well settled where the principle of the contra preference is applicable. It means the party which is drafting the contracts, the terms are to be decided against him when there is a ambiguity, all these cases. There is a legal debate on this subject. Can court interference in such contracts? So for this number of things we will have to consider while deciding such like issues, specifically by earlier it was a unfair trade practice as defined under the Consumer Protection Act 1986. Now specific definitions have been given. The relevant sections are firstly the complaint itself, section 2, subsection 6, section 9, subsection 9, subsection 46. And the other sections are section 47, 1A, 2I, section 49, subsection 2. This relates to the state commissions, and the section 58, subsection 1A, 2I, and section 59, 2 are the relevant provision which have been specifically put wherein the definitions have been given, and also authority has been provided to the state commission and national commissions where they can declare such contracts as null and void. It means the declaratory decree can also be passed by the state commission and the national commission where such like issue, when the issue is with regard to the validity of the contract and consequential terms which are unfair. If the unfair terms are to such an extent that they go to the root of the contract itself or the agreement which we are facing, then they will have to reject the entire contract and can be declared as null and void. In this aspect, when we will looking into these aspects, what are the important things which we will have to look? What the businesses say, they say that these are the contracts which have advantage both for the consumer and the businesses. Firstly is the economic efficiency and cost saving. They say that the contracts are framed in such a manner and there's really unnecessary wastage of time. When there are so many transactions in a day, this is not possible to negotiate every contract with the consumers. Second is greater certainty. For particular business, particular type of consumer contract that in the shape of standard forms are there. So they will look into that, and parties may be knowing about this and hearing from here and there and the other purchasers like this. Thirdly, the uniformity in such like contracts. Fourth is the easy altering of the contracts if need arises. On the other hand, when we look into the disadvantages which are affecting the rights of the consumers, we are supposed to look into because the terms in the contract, such like contracts are one-sided and are favorable in favor of the business houses. The imposition of unfair terms results in various type of penalties, excessive charging of interest. But on the other hand, when consumer, they are drafted by the legal professionals and experts, the terms and conditions mentioned in the contract itself are not understandable by the consumers. And in addition to it, there is a issue of behavior with regard to reading of contracts. It is rarely seen that such like voluminous contracts can be read within 10 to 15 minutes or within half an hour. Second issue is with regard to the understanding of the terms which are mentioned therein. So I would like to deal with it in a precise manner. First is the issue whether in real sense they are contract as are defined under the Contract Act. First issue is with regard to the consent. If contract is to be drafted, first there should be understanding between both the parties. They should negotiate and mention. Then thereafter the contract is required to be typed. Here what you are seeing, what is faced by the consumer, what the builder, suppose we take the instance of a builder. He will bring a contract booklet in the shape of booklet having 30 to 100 pages, maybe more, with appendixes, indexes, and so many other things, including declarations. They asked to sign on the dotted lines, or you have to decide within few minutes or maybe an hour or less than that. This is one issue which is the most crucial. If there is no proper consent and negotiation, then such a contract cannot otherwise be accepted as a contract which has been consciously entered into by the parties after looking into terms and conditions. Inequality of bargaining power. So far as the consumers are concerned, they are not in a position to bargain in such like contracts. They are bound to sign such like contracts, and such like contracts are to be accepted as it is. They have no chance to going through the various terms and conditions, which results into unnecessary bargain to the business houses, and the consumers are the sufferers. Inequality with regard to drafting. The drafting of such like contracts is done by the legal experts, which have a full-fledged legal offices, and they consider these terms and conditions mentioned in such like contracts, and thereafter draft those contracts, which are many a time hyper technical, and the understanding of the common man in this regard is very less. They cannot understand. There is no provision that before entering into a contract, legal person should be there. That too is a neutral person. There is no such type of arrangement. Mr. Vikas, many of the audiences are saying that I am not audible.
No, so it's audible.
May not be to some others, but
maybe he is not connected through speaker. Sheikh, you will have to connect yourself. First you exit and then you reconnect.
Yes. Yes. Some of the people may not be having, so they should check their audio system, whether they are properly, they have unmuted it or something is there. They should check. Yes. So even if we have an interaction session also, so no problem, they can ask the question. We will deal with it.
Right, sir.
So then such like contracts which are voluminous, they are prepared in advance. And so it becomes very difficult for the consumers, and they have to sign it, because there is a social pressure also when you are accompanying a person going to a particular business house. They also feel that I must sign it because this is a common practice going on. Another issue is with regard to no freedom of contract virtually. Freedom of contract and conscious negotiation of terms are the fundamentals for the classic contracts which we generally entered. And They are done after negotiating everything. Use of small prints is also one of the things which is mentioned in such like contracts, which is not many a time visible to the naked eye, but to talk of the naked eyes, even sometime with the magnifying glass, we cannot read the terms, which are virtually hidden and difficult to assess how they are affecting. Another is agreement restricting the legal remedies. In such like contracts, conditions are put that the consumers cannot file a appeal. There is arbitration clause, such like things which may bar a party, that specifically the consumers, to go to the various type of courts or the consumer fora or the consumer commission as they are presently working. There are many other procedural issues with regard to this. If we look into the contracts, such contracts are overloaded with the information which is mentioned, which is, I have already told, which is not understandable by the common and odd man of ordinary prudence for that reason. Another behavioral aspect is such contracts are rarely read by the parties because of these voluminous natures. And another reason is, even if they are reading, then the issue arises with regard to assessing the full terms before acceptance. Acceptance of the contract, that is very, very important. So, resulting into adverse effect in the interest of the consumers and the sufferings they feel with regard to this. Now, I will come to, for instance, builder-buyer contracts. What are the terms which are generally found in such like contracts which are unfair? Firstly, generally what a consumer knows about builder-buyer contract. It is also voluminous, running into 50, 30, 40, 50 pages, maybe more of many a time, with annexures attached to this. First is, when they are entering, the consumer knows only three things: the area of the plot number, and the sale consideration. At the most, he may be knowing that the project will be completed in particular period. But when the ground realties are checked at the spot, many conditions are put in it which are unilateral. First is changing of the zoning plan unilaterally without giving any notice to the allottee. Suppose when a allottee opt for a plot, what he does, he says that I am purchasing a plot which is facing a park, which is nearest to the commercial area. Subsequently, all of a sudden, that this park is converted into commercial complex, or some other type of construction is carried out, which already the very purpose of this. Sometimes it happens that when you are getting a corner plot, that particular road is also closed for connecting the various blocks of a particular building plan, which are made like this. Locations are many a time locations are changed. Since the zoning plan is changed, then the location is changed, and the number of plots and the situation where this plot was to be located, that is also changed consequentially. There is another clause which is generally there. When we talk of this parking area converted into a commercial area or any construction is carried out, another block is raised there. Then the question of environmental issues is also rises. When a parking area, which is a breathing place, which is providing the ambience for that particular area, are changed, then it becomes difficult for a person that he has wrongly accepted this plot. So converting plots into the park area into construction, otherwise also is affecting firstly the vegetation area, consequential oxygen output, which oxygen is being produced in the area by the trees and plants and other fragrance, etc. These things are affected like this. And when there is a delay in projects, there is no compensation paid. But if there is a delay in payment of installments, they charge an excessive interest. Penalty clauses are added to it. But if there is a delay in the project, nothing is done. But no compensation is reciprocal. Terms are missing in such like contracts. Suppose there is a specified period for 3 years that project will be completed. Many a time we have seen that this amount which has been paid by the allottee of a particular project are misused to other projects where they create their own another project, but this project remains incomplete for many years. Instead of 3 years, it may take 9 to 10 years and maybe more. The general principle and the expectation of a consumer is that he wants a roof over his head. That it should be provided within a limited time, within a reasonable time, so that he may stay there and enjoy the life. And specifically in the fag end, specifically when the employees are there, they opt when they are about to retire for such like situation. Otherwise, they are staying in the government accommodations like which are provided. Then it becomes very difficult. All of a sudden, they have to go for rent. There is no provision. If that is not provided, then the party with the builder or the business houses, they will provide the rent, equivalent rent or the proportionate market rent available in the particular area where the plot are situated. These types of are the common. Then we come to the insurance contracts. Insurance contracts,
So we will take the question later on.
question we will take a later. Then we will look into this.
Yes, sir.
Let me finish my lecture. When the interaction section rise, then you can raise question. We will answer. I will try to answer those questions. Suppose we are looking into the insurance contracts. Firstly, nobody fills the complete form. Only some of the columns are filled by the agent which comes. And he put the ticks on here and there in the boxes, where many times such ticks are affecting the rights of the consumers. There are otherwise ifs and buts mentioned and the exclusion clauses are mentioned. The fundamental rule is if you have to exclude a person, any exclusion clause is to be used against a consumer, then it must be got specifically signed and should be shown in bold. What happens? Contracts are coming in typed in English, printed in English, and in fine prints. Who is signing? A rustic villager or a illiterate person putting their thumb impressions. Then they have accepted it. Where is the issue? Can he know the language? Why it can't be? Is there any authentication provided by a person that the person who explained the contents, when contract was started, and how much time it was taken for signing that? These are the issues which we find and resulting into rejection of the claims. Similarly, the bank's issues. Bank also, you are mortgaging property. Now there are other securitization act provisions are there, then they can sell your property once the mortgage, it continue to be mortgage multiplying, the penalty in many ways, and they are affecting that. They are not looking into the ground reality. There may be reasons for delay in payment of installments. Banks do not wait. They are waiving thousands and crores of rupees. What are charging, depriving the person of the house because there is some delay in payments of installments. I came across a case while I was a judge of the High Court in RSA. State Bank of Patiala issue was there. And loan was advanced by the bank to a class 4 employee. He was regularly paying the installments. All of a sudden, he died. Because there is a provision in the loan, when the loan are there, they are deducting some installment with for insurance, securing the loans. Insurance is always there. Still, because the intimation was not provided, but death is death. Death is certain once the person has been found to be dead. Then what inquiries you have been made? You are charging the lady or the children's after 6 months. What is your regular, why the installments are, had anybody inquired about that? Then I happened to call the DGM of that bank and asked him, provide the information, how many loans have been written off, and whether you are in a position to recover it from the insurance company once you are deducting the premium out of the installments paid by this person. Have you checked that the why this insurance could not be renewed? It is your duty when the installments are not paid and ultimately found to be the validity of the consumer contract. The insurance was even after the date of death, validity was still existing, but the man has died. At least on the day when the insurance was to be expired, only then they should have come and checked from that person that these installments are also due and this is happening. Then they should have come about the entire situation. And the situation like this are the common practice in such like cases. Now, if we look into the definition, complaint, section 2, subsection 6. Now this word unfair contract has been mentioned. If we read this, complaint means any allegation in writing made by a complainant for obtaining any relief provided by or under this act that an unfair contract or unfair trade practice or restrictive trade has been adopted by the trader or the service provider. One, this has been specifically added into it. Earlier, it was an unfair contract was not added. Then we come to the definition. We will read section subsection 46. Unfair contract. Unfair contract means a contract between manufacturer or trader or service provider on one hand and the consumer on the other hand, having such terms which cause significant changes in the rights of such consumer, including the following. When we read this provision, we have to look into the subsection 9 also. Consumer rights. Because it talks of the rights of such consumer. So when we have to look into and frame our complaints, and as a judge or the member of the fora, when you are deciding, you will have to look into the definition of the consumer rights, and that provision are to be read with this. Now we see another section 47(1)(a) and 2(i). Subject to the other provisions of this act, State Commission shall have jurisdiction to entertain complaint. That is the normal. Second is 2(i) is complaint against unfair contracts where the value of goods or the services provided as consideration does not exceed 2 crore. Now earlier it was mentioned 10 crore. Now it is only 2 crore. Here means if we have to look into that, if you are challenging the terms and conditions of a contract which has been entered into between the parties, then the value starts from 1 rupee to 2 crore, because this is an issue of validity of contract which can be decided under section 49(2). 49(2) says the declaration can be granted by the commission without prejudice to the provision of section 1. State Commission may also declare any term of the contract which shall be unfair to any consumer to be null and void. If we accumulate effect of the entire terms and condition, which majority of the terms and conditions are found to be unfair, then the ultimate result is that contract is to be declared null and void. This power has been specifically provided under the Act, which can be done by the State Commission. Identical provision is more than 2 crore amount is given to the National Commission. The District Commission has no power in such cases. For that reason, I will say that the jurisdiction of the State Commission, I'm just repeating, of the State Commission commence from the lowest value up to the highest value of commission, that is 2 crore. That can be challenged in the State Commission straightway instead of going the District Commission. You are not required when you are challenging the terms being unfair in the contract. So complaint itself is maintainable before the State Commission or the National Commission, subject to the consideration paid with regard to that issue. You will have to look into that aspects. So these are the terms. So far as this National Commission is concerned, the relevant sections are 58 and 59. 58, subsection 1, further subsection 8 and 2(i), and section 59, subsection 2. These are the relevant provisions for this. Now we will look into what we will go back again to the definition, that is the section 46, section 2, subsection 46. There is a list of unfair terms given in this, but this is not an exhaustive list. Ultimately, the court will decide looking into all the facts of that which are relevant and which also amount to 6-7 terms which are mentioned here. Unfair contract that we have already requiring manifestly excessive security deposits to be given by the consumer for of contractual obligations. When you are asking excessive security, it may be a bank guarantee or it may be otherwise security, then its valuable consideration is required. It is certainly a valuable consideration. What is the reciprocal arrangement? Will for that security, if they are asking deposit 50 lakhs, will they pay us any interest on that? If such excessive securities are demanded and no reciprocal arrangement is there, then it will be treated as a unfair terms. This is my understanding so far as law is concerned. So second is imposing penalty on consumers for breach of contract, which is wholly disproportionate. One installment not paid, the entire amount paid is to be forfeited. The circumstances are to be seen like this, whether such a condition can be looked into. Is it not a unfair terms? These are to be considered in a wider perspective, and these whatever conditions, I am not required to read all these 6 conditions, but they can be multiplied and used in an equitable manner, which may not be disadvantage to the consumer as well as to the business houses, but the cumulative effect of the unfair terms should be seen, whether it should be declared null and void or not. These are the some fundamentals which we can look into all this. Mr. Vikas, we may continue or we may start interaction. Hello.
We can wind up, then we will take it in Punjabi, and thereafter we will take questions.
Okay.
Yes.
So I have tried to explain in English. Now I will have to, as directed by Mr. Vikas, I will try to explain in Punjabi. Consumer Act ਦੇ section 2 ਦੇ ਵਿੱਚ specifically subsection 6, a definition has been given, ਜਿਹਦੇ ਵਿੱਚ ਇਹ ਲਿਖਿਆ ਗਿਆ ਹੈ ਕਿ ਵੀ ਜਿਹੜਾ ਕੰਟਰੈਕਟ ਹੈ ਜਿਹਦੀਆਂ ਧਾਰਾਵਾਂ ਇੱਕ ਤਰਫਾ ਕੰਜ਼ਿਊਮਰ ਦੇ ਹੱਕ ਦੇ ਖਿਲਾਫ ਹੁਣ ਉਹਨਾਂ ਬਾਰੇ ਜ਼ਿਕਰ ਕੀਤਾ ਗਿਆ ਹੈ, ਉਹਦੀ ਡਿਫਾਈਨ ਕੀਤਾ ਗਿਆ, ਉਹ ਕੰਪਲੇਂਟ ਦਾ ਪਾਰਟ ਮੰਨੀ ਜਾਏਗੀ। ਨਾਓ ਇਸ ਤਹਿਤ ਵੀ ਇੱਕ ਕੰਪਲੇਂਟ ਫਾਈਲ ਕੀਤੀ ਜਾ ਸਕਦੀ ਹੈ। ਦੂਸਰਾ ਕੰਜ਼ਿਊਮਰ ਰਾਈਟਸ ਬਾਰੇ ਕਿਹਾ ਗਿਆ ਹੈ, ਸਬ ਸੈਕਸ਼ਨ ਜਿਹੜਾ ਇਹਦਾ 9ਵਾਂ ਧਾਰਾ 9 ਹੈ ਦੀ ਉਪ ਧਾਰਾ 9 ਹੈ 2 ਸੈਕਸ਼ਨ 2 ਦੀ, ਉਸ ਦੇ ਥੱਲੇ ਉਹਨੂੰ ਡਿਫਾਈਨ ਕੀਤਾ ਗਿਆ। ਉਪ ਧਾਰਾ 2 ਸੈਕਸ਼ਨ 2 ਦੀ ਉਪ ਧਾਰਾ 46 ਦੇ ਵਿੱਚ ਇੱਕ ਜਿਹੜੀਆਂ ਕੰਡੀਸ਼ਨਾਂ ਲੇ ਡਾਊਨ ਕੀਤੀਆਂ ਗਈਆਂ, ਕਿਹੜੀਆਂ ਕਿਹੜੀਆਂ ਇਹ ਉਹ ਹੈ ਜਿਨ੍ਹਾਂ ਨੂੰ ਅਨਫੇਅਰ ਕਿਹਾ ਗਿਆ ਹੈ। ਇਹ ਨਹੀਂ ਹੈ ਕਿ ਵੀ ਓਨਲੀ ਇਹ 6 ਕੰਡੀਸ਼ਨ ਸਫੀਸ਼ੀਐਂਟ ਹੈ। other conditions which are to be imagined and seen equitably, keeping into the equity interest of both the business houses as well as the consumers. ਖਪਤਕਾਰਾਂ ਤੇ ਦੋਨਾਂ ਦਾ ਧਿਆਨ ਰੱਖਦੇ ਹੋਏ ਇਸ ਨੂੰ ਦੇਖਿਆ ਜਾਵੇਗਾ। ਹੁਣ ਕੰਜ਼ਿਊਮਰ ਰਾਈਟਸ ਦੇ ਧਿਆਨ 'ਚ ਰੱਖਦੇ ਹੋਏ, ਕੰਪਲੇਂਟ ਦੀ ਡੈਫੀਨੇਸ਼ਨ ਨੂੰ ਧਿਆਨ 'ਚ ਰੱਖਦੇ ਹੋਏ, ਜਿਹੜੇ ਰਾਜਾਂ ਦੇ ਕੰਜ਼ਿਊਮਰ ਕਮਿਸ਼ਨ, ਉਹਨਾਂ ਨੂੰ ਇਹ ਅਧਿਕਾਰ ਦਿੱਤਾ ਗਿਆ ਜੇ ਉਹਦੇ ਜਿਹੜਾ ਵੀ ਤੁਸੀਂ ਕੋਈ ਐਗਰੀਮੈਂਟ ਜਿਹੜਾ ਵੀ ਤੁਸੀਂ ਲਿਖਤ ਕੀਤੀ ਹੈ ਮਕਾਨ ਲੈਣ ਲਈ, ਇੰਸ਼ੋਰੈਂਸ ਲਈ ਜਾਂ ਬੈਂਕ ਤੋਂ ਲੋਨ ਲਈ, ਕੀ ਉਹਦੀਆਂ ਧਾਰਾਵਾਂ ਸਹੀ ਨੇ, ਕੀ ਉਹ ਧਾਰਾਵਾਂ ਇੱਕ ਤਰਫਾ ਤਾਂ ਨਹੀਂ। ਇਹ ਸਾਰੀਆਂ ਗੱਲਾਂ ਨੂੰ ਦੇਖਿਆ ਜਾ ਸਕਦਾ ਹੈ ਕੰਜ਼ਿਊਮਰ ਦੇ ਕੇਸਾਂ ਦੇ ਵਿੱਚ। ਕੰਜ਼ਿਊਮਰ ਹੁਣ ਧਾਰਾ 47 ਦੇ ਤਹਿਤ ਜੋ ਨਵਾਂ ਐਕਟ 2019 ਦਾ ਕੰਜ਼ਿਊਮਰ ਐਕਟ ਬਣਿਆ, ਉਹਦੇ ਤਹਿਤ ਉਹਨਾਂ ਨੂੰ ਇਹ ਕਹਿ ਲਗੇ ਵੀ ਇਹ ਸਾਰੀਆਂ ਦਾ ਕੋਈ ਸਾਡੇ ਤੇ ਅਸਰ ਨਹੀਂ, ਉਸ ਨੂੰ ਐਕਸਪਲੇਨ ਕੀਤਾ ਜਾ ਸਕਦਾ। ਮੈਮ, I have already explained in English. Now I am only giving Punjabi version. Still we will, you may have come delayed, Miss Sonia. Yes. So anyway, we will still, I am here to explain to you whatever you want. So this is the another issue. ਜੇ ਤੁਹਾਡੀ ਅਮਾਉਂਟ 1 ਰੁਪਏ ਤੋਂ ਲੈ ਕੇ 2 ਕਰੋੜ ਤੱਕ ਹੈ। ਤੁਸੀਂ ਸਟੇਟ ਕੰਜ਼ਿਊਮਰ ਕਮਿਸ਼ਨ ਜਿਹੜਾ ਰਾਜ ਖਪਤਕਾਰ ਕਮਿਸ਼ਨ ਹੈ ਕੰਸਰਨਡ ਰਾਜ ਦਾ, ਉੱਥੇ ਫਾਈਲ ਕਰ ਸਕਦੇ ਹੋ। ਪੰਜਾਬੀ ਵਾਲਿਆਂ ਨੂੰ ਤਾਂ ਹੁਣ ਪੰਜਾਬ ਦੇ ਬਾਰੇ ਗੱਲ ਹੋਏਗੀ। ਇਹ ਜਿਹੜਾ ਅਧਿਕਾਰ ਹੈ ਰਾਜ ਕਮਿਸ਼ਨ ਨੂੰ ਹੈ, ਸਟੇਟ ਕਮਿਸ਼ਨ ਨੂੰ ਹੈ, ਨਾ ਕਿ ਡਿਸਟ੍ਰਿਕਟ ਕਮਿਸ਼ਨ ਨੂੰ, ਜ਼ਿਲ੍ਹਾ ਕਮਿਸ਼ਨਾਂ ਨੂੰ ਇਹ ਅਧਿਕਾਰ ਨਹੀਂ ਹੈ। ਇਸੇ ਤਰ੍ਹਾਂ ਜੇ 2 ਕਰੋੜ ਤੋਂ ਵੱਧ ਹੈ ਤਾਂ ਸਿੱਧਾ ਕੇਸ ਅਸੀਂ ਉੱਥੇ ਪਾ ਸਕਦੇ ਹਾਂ ਨੈਸ਼ਨਲ ਕਮਿਸ਼ਨ ਦੇ ਵਿੱਚ, ਤੇ ਉਸ ਤਰ੍ਹਾਂ ਦੇ ਸੇਮ ਹੀ ਰਾਈਟ ਹੈ, ਸੇਮ ਹੀ ਪ੍ਰੋਵੀਜ਼ਨਸ ਹੈ ਇਸ ਬਾਰੇ। ਇਹ ਕੰਟਰੈਕਟ ਜਿਹੜੇ ਹੈਗੇ ਕੀ ਕਹਿੰਦੇ ਨੇ ਬਿਜ਼ਨਸ ਵਾਲੇ, ਉਹ ਕਹਿੰਦੇ ਵੀ ਸਾਨੂੰ ਹਜ਼ਾਰਾਂ ਹੀ ਟ੍ਰਾਂਜੈਕਸ਼ਨਾਂ ਕਰਨੀਆਂ ਪੈਂਦੀਆਂ ਇੱਕ ਦਿਨ 'ਚ, ਵੇਚਣਾ ਪੈਂਦਾ, ਮਲਟੀਪਲ ਟ੍ਰਾਂਜੈਕਸ਼ਨਸ ਹੁੰਦੀਆਂ, ਤੇ ਅਸੀਂ ਰੋਜ਼ ਨਵਾਂ ਇਸ ਤਰ੍ਹਾਂ ਦਾ ਉਹ ਨਹੀਂ ਕਰ ਸਕਦੇ। ਇਸ ਲਈ ਇਹ ਫਰੇਮ ਕੀਤੇ ਹੈ। ਇਹ ਨੰਬਰ ਆਫ ਇਹਦਾ ਫਾਇਦਾ, ਸਾਡੀ ਕਾਸਟ ਵੀ ਘਟਦੀ ਹੈ, ਉਹ ਕਾਸਟ ਦਾ ਖਰਚਾ ਕੰਜ਼ਿਊਮਰ ਤੇ ਪੈਂਦਾ ਉਹ ਵੀ ਘਟ ਜਾਂਦਾ ਹੈ। ਇਹ ਗੱਲਾਂ ਨੂੰ ਧਿਆਨ 'ਚ ਰੱਖਦੇ ਅਸੀਂ ਇਹ ਬਣਾ ਲੈਂਦੇ ਹਾਂ। ਜਦੋਂ ਅਸੀਂ ਉਹਨਾਂ ਦੀ ਗੱਲ ਮੰਨ ਲਈਏ, ਪਹਿਲਾਂ ਤਾਂ ਸਾਨੂੰ ਦੇਖਣ ਤੇ ਠੀਕ ਲੱਗਦੀ ਹੈ, ਪਰ ਜਦੋਂ ਦੂਜੇ ਉਹ ਕਹਿੰਦੇ ਨੇ ਵੀ ਇਹ ਪੱਕੇ ਹੋ ਗਏ, ਵੀ ਇਹ ਸਰਟਨ ਹੈ, ਵੀ ਆਹੀ ਗੱਲ ਕਹੀ ਹੋਈ ਹੈ ਸਾਰੇ ਕੰਟਰੈਕਟਾਂ 'ਚ। ਇੱਕ ਥਾਂ ਦੇ ਜੇ ਮਕਾਨ ਲੈਣ ਵਾਲੇ ਤਕਰੀਬਨ ਸਾਰੇ ਕੰਟਰੈਕਟ ਇੱਕ ਕਿਸਮ ਦੇ ਹੁੰਦੇ ਨੇ, ਸਾਰਿਆਂ 'ਚ ਇੱਕ ਸਮਾਨਤਾ ਹੈ ਸਾਰੇ ਕੰਟਰੈਕਟਾਂ ਦੇ ਵਿੱਚ, ਤੇ ਇਹਨਾਂ ਨੂੰ ਤੁਸੀਂ ਬਦਲ ਵੀ ਸਕਦੇ ਹੋ। ਪਰ ਇਹ ਜਿਹੜੇ ਅਧਿਕਾਰ ਹੈ ਉਹ ਇੱਕ ਤਰਫਾ ਦਿੱਤੇ ਗਏ ਨੇ, ਕਿਉਂਕਿ ਜਿਹੜਾ ਬੰਦਾ ਬਣਾਉਂਦਾ ਇਸ ਕੰਟਰੈਕਟ ਨੂੰ, ਉਹ ਸਾਰੀਆਂ ਧਾਰਾਵਾਂ ਆਪਣੇ ਫੇਵਰ 'ਚ ਲੱਗਣ। ਇਹ ਜਿਹੜਾ ਆਮ ਸਾਡਾ ਕੰਟਰੈਕਟ ਐਕਟ ਹੈ, ਕਿਸੇ ਨਾਲ ਸੌਦਾ ਕਰਨ ਵਾਸਤੇ ਜਦੋਂ ਅਸੀਂ ਕੋਈ ਇਸ ਤਰ੍ਹਾਂ ਦੀ ਉਹ ਕਰਦੇ ਹਾਂ, ਤਾਂ ਉਹਦੇ ਉਲਟ ਹੈ। ਉਹ ਇਹ ਕਹਿੰਦਾ ਵੀ ਜਦੋਂ ਤੁਸੀਂ ਕੰਟਰੈਕਟ ਦੇ ਵਿੱਚ ਜਾਣਾ ਹੈ, ਤੁਹਾਨੂੰ ਪਤਾ ਹੋਣਾ ਚਾਹੀਦਾ ਵੀ ਕੀ ਚੀਜ਼ ਹੈ, ਤੁਹਾਨੂੰ ਉਹ ਗੱਲ ਡਿਸਕਸ ਹੋਣੀ ਚਾਹੀਦੀ ਹੈ, ਤੇ ਫਿਰ ਤੁਸੀਂ ਸਾਈਨ ਕਰਨਾ ਹੈ ਉਹ ਕੰਟਰੈਕਟ। ਉਸ ਤਰ੍ਹਾਂ ਤਾਂ ਹੀ ਉਹ ਬਾਈਂਡਿੰਗ ਹੋ ਸਕਦਾ, ਨਹੀਂ ਹੋ ਸਕਦਾ। ਇਸ ਜਿਹੜੀਆਂ ਤੁਸੀਂ ਇੱਕ ਤਰਫਾ ਉਹ ਦਿੱਤੀਆਂ ਹੋਈਆਂ, ਉਹ ਜਿਹੜੀਆਂ ਟਰਮਸ ਹੈ, ਉਹ ਨਵੇਂ ਐਕਟ ਦੇ ਮੁਤਾਬਕ, ਪਹਿਲਾਂ ਕੰਟਰੈਕਟ ਦੇ ਵਿੱਚ ਐਸਾ ਕੋਈ ਨਹੀਂ ਸੀ। ਸਮ ਆਫ ਦੀ ਕੰਸੀਡਰੇਸ਼ਨ ਵਰ देयर, ਮਿਸਰਿਪਰੈਜ਼ੈਂਟੇਸ਼ਨ, ਫਰਾਡ ਐਂਡ ਅਦਰ ਥਿੰਗਸ, ਸੈਕਸ਼ਨ 29 ਐਕਸੈਟਰਾ, ਉਹ ਰੈਲੇਵੈਂਟ ਸੀ ਆਫ ਦੀ ਕੰਟਰੈਕਟ ਐਕਟ। ਬਟ ਹੁਣ ਤਾਂ ਸਪੈਸੀਫਿਕਲੀ ਇਹ ਧਾਰਾਵਾਂ ਕੰਜ਼ਿਊਮਰ ਐਕਟ ਦੇ ਵਿੱਚ ਐਡ ਕਰ ਦਿੱਤੀਆਂ ਗਈਆਂ, ਇਸ ਲਈ ਦੇ ਆਰ ਰੈਲੇਵੈਂਟ। ਪਹਿਲੀ ਗੱਲ ਤਾਂ ਕੰਸੈਂਟ ਕੋਈ ਨਹੀਂ ਲਈ ਜਾਂਦੀ ਇਹਦੇ 'ਚ, ਪ੍ਰੋਪਰ ਕੰਸੈਂਟ ਨਹੀਂ, ਖਾਲੀ ਜਿਹੜੀਆਂ 40-50 ਪੇਜ ਹੁੰਦੇ ਆ ਉਹਨਾਂ ਤੇ ਦਸਤਖਤ ਹੀ ਕਰਨਾ ਹੁੰਦਾ, ਤੁਹਾਨੂੰ 2-3 ਚੀਜ਼ਾਂ ਦਾ ਹੀ ਪਤਾ ਹੁੰਦਾ। ਦੂਜਾ, ਉਹਦੀਆਂ ਜਿਹੜੀ ਹੈਗੀ, ਤੁਸੀਂ ਉਹਨੂੰ ਚੰਗੀ ਤਰ੍ਹਾਂ ਪੜ੍ਹਿਆ ਨਹੀਂ ਹੁੰਦਾ, ਜੇ ਪੜ੍ਹਿਆ ਵੀ ਹੁੰਦਾ ਤੁਹਾਨੂੰ ਸਮਝ ਨਹੀਂ ਆਉਂਦੀ, ਕਿਉਂਕਿ ਕਾਨੂੰਨੀ ਨੁਕਤੇ ਲਿਖੇ ਹੁੰਦੇ ਨੇ, ਆਮ ਬੰਦੇ ਦੀ ਸਮਝ ਤੋਂ ਬਾਹਰ ਹੁੰਦੇ ਨੇ ਉਹ। ਫਿਰ ਇਹ ਇੱਕ ਤਰਫਾ ਹੀ ਪ੍ਰਪੇਅਰ ਹੁੰਦੇ ਨੇ। ਕੋਈ ਜਿਹੜੀ ਬੇਸਿਕ ਪ੍ਰਿੰਸੀਪਲ ਹੈ ਕੌਨਸ਼ੀਅਸ ਨੈਗੋਸ਼ੀਏਸ਼ਨ ਐਂਡ ਫਰੀडम ਆਫ ਕੰਟਰੈਕਟ, ਉਹ ਇਹਦੇ 'ਚ ਨਹੀਂ ਹੁੰਦੀ। ਤੁਹਾਨੂੰ ਸਾਈਨ ਹੀ ਕਰਨੇ ਪੈਂਦੇ ਆ, ਉਹ ਸਾਰੀਆਂ ਲੈਣਾ, ਨਹੀਂ ਕਰਨਾ ਕਰੋ, ਨਹੀਂ ਤਾਂ ਜਾਓ ਆਪਦੇ ਘਰ ਨੂੰ। ਇਹ ਸਾਰੀਆਂ ਚੀਜ਼ਾਂ ਇਹ ਹੁੰਦੀਆਂ। ਕੁਝ ਚੀਜ਼ਾਂ ਉਹ ਛੋਟਾ ਪ੍ਰਿੰਟ ਕਰਕੇ ਨਾ ਸਟਾਰ ਲਾ ਕੇ ਲਿਖ ਦਿੰਦੇ ਆ, ਜਿਹੜੀਆਂ ਸਮਝੀਆਂ ਨਹੀਂ ਜਾ ਸਕਦੀਆਂ, ਦੇਖੀਆਂ ਨਹੀਂ ਜਾ ਸਕਦੀਆਂ, ਉਹ ਅੰਡਰਸਟੈਂਡ ਹੀ ਨਹੀਂ ਕੀਤੀਆਂ ਜਾ ਸਕਦੀਆਂ, ਉਹਦਾ ਲਿੰਕ ਕਿਹਦੇ ਨਾਲ ਹੈ, ਕਿਵੇਂ ਹੈ। ਇਸੇ ਤਰ੍ਹਾਂ ਹੀ ਕੋਈ ਤੁਹਾਡੇ ਰਾਈਟਸ ਨੂੰ ਵੀ ਕਹਿ ਦਿੰਦੇ ਆ ਕਿ ਵੀ ਨਹੀਂ, ਤੁਸੀਂ ਅਪੀਲ ਨਹੀਂ ਕਰ ਸਕੋਗੇ, ਤੁਸੀਂ ਜਾ ਨਹੀਂ ਸਕੋਗੇ, ਜੇ ਕਰਨਾ ਹੈ ਤਾਂ ਸਾਡੇ ਕੋਲੇ ਸਾਡਾ ਆਰਬਿਟ੍ਰੇਸ਼ਨ ਹੋਊਗਾ, ਆਰਬਿਟਰੇਟਰ ਵੀ ਸਾਡਾ ਆਪਣਾ ਹੋਏਗਾ। ਇਹ ਸਾਰੀਆਂ ਚੀਜ਼ਾਂ ਇਹਦੇ ਵਿੱਚ ਕੀਤੀਆਂ ਗਈਆਂ, ਜਿਹੜੀਆਂ ਕਿ ਕਈ ਕਿਸਮ ਦੇ ਪ੍ਰੋਸੀਜਰਲ ਇਸ਼ੂ ਕ੍ਰੀਏਟ ਕਰਦੀਆਂ। ਉਹ ਮਤਲਬ ਇਹ ਆਮ ਜਾਣਕਾਰੀ ਦਾ ਵਿਸ਼ਾ ਤਾਂ ਬੜਾ ਲੰਬਾ ਹੈ, ਇਸ ਬਾਰੇ ਵੀ ਪ੍ਰੋਸੀਜਰਲ ਕਿਵੇਂ ਇਸ਼ੂ ਹੁੰਦੇ ਆ, ਕੀ ਦੇਖਣਾ, ਉਹ ਸਾਰਾ ਕੁਝ ਦੇਖਿਆ ਜਾਂਦਾ। ਇਸ ਸੰਬੰਧ ਦੇ ਵਿੱਚ ਸਾਡੀ ਆਪਣੀ ਘਾਟ ਹੈ। There is one. I have already spoken, Mrs. Sundaresan. I have spoken in English earlier. Now it is only Punjabi version of that.
Those who have joined late, they can always watch this session on the YouTube.
Yes.
Justice Dhaliwal has already spoken in English, or he's just giving the gist in Punjabi. Since he comes from Punjab and Haryana, people know that he has a flair with that. Therefore, he's just giving a gist of that what he has spoken already.
So, ਪੜ੍ਹਨ ਦਾ ਜਿਹੜਾ ਸਾਡਾ ਸੁਭਾਅ ਹੈ ਨਾ, ਆਮ ਬੰਦਿਆਂ ਦਾ, ਚਾਹੇ ਉਹ ਕੰਜ਼ਿਊਮਰ ਹੋਣ ਚਾਹੇ ਕੋਈ ਵੀ ਹੋਰ ਹੋਣ, ਖਾਸ ਕਰਕੇ ਜਿਹੜੇ ਪਿੰਡਾਂ ਤੋਂ ਆਉਂਦੇ ਆ, ਜਿਨ੍ਹਾਂ ਦੀ ਬੈਕਗ੍ਰਾਉਂਡ ਪਿੰਡਾਂ ਤੋਂ ਹੁੰਦੇ ਆ, ਉਹਨਾਂ ਨੂੰ ਉਹ 100 ਪੇਜ 5 ਮਿੰਟਾਂ 10 ਮਿੰਟਾਂ 'ਚ ਪੜ੍ਹ ਕੇ ਦਸਤਖਤ ਕਰਨਾ ਬੜਾ ਮੁਸ਼ਕਲ ਹੈ। ਅਦਰਵਾਈਜ਼ ਸਾਡਾ, ਮੈਂ ਖੁਦ ਦਾ ਆਪਣਾ ਐਕਸਪੀਰੀਅੰਸ ਕਰਦਾ, ਤੁਹਾਡੇ ਚੋਂ ਸਾਰੇ ਮੈਜੋਰਟੀ ਉਹ ਜਿਹੜੇ ਬੰਦੇ ਹੋਣਗੇ, ਉਹਨਾਂ ਨੇ ਕਦੇ ਵੀ ਕੋਈ ਕੰਟਰੈਕਟ ਜਿਹੜਾ ਬੈਂਕ ਤੋਂ ਲੋਨ ਲੱਗਿਆ ਸਾਈਨ ਹੀ ਕੀਤੇ ਹੁੰਦੇ ਆ। ਤੁਸੀਂ ਬਾਕੀ ਪਤਾ ਹੀ ਨਹੀਂ ਹੁੰਦਾ ਵੀ ਅਮਾਉਂਟ ਕਿੰਨੀ ਹੈ। ਇੰਸ਼ੋਰੈਂਸ ਲੈਣ ਲੱਗਿਆ ਤੁਸੀਂ ਕੁਝ ਨਹੀਂ, ਸਾਈਨ ਹੀ ਕਰਦੇ ਹੋ, 100 ਪੇਜ ਉਹਨਾਂ ਦਾ ਖਾਲੀ। ਇਸੇ ਤਰ੍ਹਾਂ ਹੀ ਬਿਲਡਰਸ ਦਾ ਹੁੰਦਾ। ਇਹ ਸਾਰੀਆਂ ਸਾਨੂੰ 3 ਚੀਜ਼ਾਂ ਪਤਾ ਹੁੰਦਾ ਵੀ ਕਿੰਨੇ ਪੈਸੇ ਲੈ ਲਏ, ਕਿੰਨੀ ਅਮਾਉਂਟ, ਕੀ ਅਸੀਂ ਉਹਦੇ ਵਾਸਤੇ ਸਿਕਿਉਰਿਟੀ ਦਿੱਤੀ ਹੈ। ਉਹ ਤੁਹਾਡੀ ਸਿਕਿਉਰਿਟੀ 5 ਕਰੋੜ ਦੀ ਹੁੰਦੀ ਹੈ, ਲੋਨ ਤੁਹਾਨੂੰ 50,000 ਦਿੰਦਾ, 5 ਕਰੋੜ ਨੂੰ 50,000 ਚ ਵੇਚ ਦਿੰਦੇ ਆ ਤੁਹਾਡਾ। ਇਹ ਉਹ ਕਿਹੜੀਆਂ ਉਹ ਟਰਮਸ ਹੈ, ਉਹ ਸਾਰੀਆਂ ਅਨਫੇਅਰ ਹੁੰਦੀਆਂ। ਇਸ ਤਰ੍ਹਾਂ ਦੀਆਂ ਸਿਚੁਏਸ਼ਨ ਹੈਗੀ, ਤੇ ਸਾਨੂੰ ਪੜ੍ਹਨ ਦੀ ਆਦਤ ਨਹੀਂ। ਪੜ੍ਹਨ ਦੀ, ਜੇ ਅਸੀਂ ਪੜ੍ਹ ਵੀ ਲਵਾਂਗੇ ਸਾਨੂੰ ਸਮਝ ਨਹੀਂ ਆਉਂਦੀ। ਉਹਦੀ ਇਨਫੋਰਮੇਸ਼ਨ ਹੀ ਉਹਦੇ ਚ ਇੰਨੀ ਲੋਡ ਕੀਤੀ ਹੁੰਦੀ ਹੈ, ਕਿਉਂਕਿ ਉਹਨਾਂ ਨੇ ਐਕਸਪਰਟ ਨਾਲ, ਲੀਗਲ ਐਕਸਪਰਟਸ ਨਾਲ ਮਿਲ ਕੇ ਇਹ ਸਾਰੀ ਚੀਜ਼ ਸੈਟਅਪ ਕੀਤੀ ਹੁੰਦੀ ਹੈ। So I think this will be sufficient, Mr. Vikas. Hello.
Yes, sir. Yes, sir. Now we will be taking the questions that will be in English.
Yes, I will take one by one. You tell me one by one. Every question will be taken.
Yes, Himanshu Atri says, sir, do you find any necessary changes which can be done in the legislation to mitigate such malpractice?
I have suggested so many changes, but nobody cares. If you look into that, firstly, this procedure I have suggested, why can't it be at the district level? Such a provision, because the person who is appointed as a president of the state commission, he is qualified to be appointed as a district judge, and his pay is also on the same. This should be, firstly, this should also be done, because basic issue should be sorted out at the district level. Why they should come to the state capital for this purpose, where the state commissions are established? One thing. Secondly, procedure should be more succinct. The definitions of unfair terms should be exhaustive one. Many things can be added into it, which we have to infer from the circumstances. Instead, we have to satisfy in this. It is not sufficient that only few 6 the terms have been mentioned and the rest are there. But still the courts are presuming and looking into the circumstances, all these things are being done. Thirdly, product liability issue. There is no provision for appeal against the order in case of product liability. There are many more in this case which require this reads and relook. Another thing, when we are asking for a contracts, such like standard form of contracts, there should be some body, regulatory body, which should examine these contracts and the terms of the contract. Because if that is examined by the independent body, the regulatory authority, then the consumer will be safe. They can look into the terms and their dues and misdues, and that can be examined. Only then that approved form, say for insurance also, for banking loans also, for builders also, and others also, wherever this such type of forms are used, can be looked into for that part. That regarding that, this is a necessity, so that consumer may not suffer, and unnecessary litigation is also prevented in this manner. Many more. Yes, that's all.
So one question is, this is by Pradeep Kumar. He says that a party had booked an auditorium for the son's marriage. However, due to COVID, it was cancelled, and that too it was informed prior in time. There were many of the conditions amongst them, and one amongst them was, if the auditorium could not be let out on the date on which it was reserved earlier, the money would not be refunded. The contract was signed by the party. Whether such a contract would hold good or not.
Yes, that contract can be challenged. This is an unfair contract, because this is a vis measure, force majeure. Something has all of a sudden has happened. There was no intentional. That is sufficiently he can approach the commission and they are bound to refund. Even otherwise, there is this courtesy demand that this is a natural event has happened for one reason or the other. Then they, at the most, they can ask for some 5% or 10% of that, not the entire one. They are bound to refund it. They will have, I'm sure if such a case has before the commissions, consumer commission specifically, they will certainly take a lenient view regarding this, and they will take into the force majeure system which says that the unnecessary things, the unnatural things are happening all of a sudden. That forfeiture clause is only implemented when there is a intentional non-compliance of the provisions. Where this has been unavoidable reasons, this has happened, then my opinion, that is a good case. Yes.
This is by Swapan Nandi only gives suggestion. He says law needs to suit as per the society need. Presently, in the Indian society, builders, insurance providers, bankers have a practice to put a cause for unfair practice. And that's why we have done the session, Mr. Swapan, to have the insights as to how one can cut across the unfair clauses provided in the standard formats. This is by Dr. Narasimha, which he had posted. So, interpretation of clauses of standard form of contracts are as per normal rules of construction or any special rule. This question is in the light of the fact that the consumer is always at receiving end of the bargain, and there will be unequal freedom of bargaining powers between the two parties. What remedies of the courts can extend in such conditions?
These so far as these provisions are concerned, now they have specifically mentioned in section this 46, subsection 46 of section 2, they have defined certain terms. Then we can look into that, and that can be examined from that point of view. Many judgments has come. If the the terms are unfair, that we will have to look into the facts and circumstances of each case, whether this is a equitable term or a unfair terms. We will have to look into from that angle, specifically with reference to subsection 46 of the section 2 of the Consumer Protection Act, which has given 6 conditions. These are specified that unreasonable charges, obligation, conditions which put such consumers to disadvantage. These are all factors to be taken into consideration, including not only this, that behavior aspects can also be taken into that aspects, whether the consumer have read it or not. These are the consumer protections. Being a Consumer Protection Act being a benevolent and beneficial for the consumers, so its liberal approach should be present. Then if you look into the subsection 9, consumer rights, it directs the commissions. Read 9, this clause, I think 3, right to be assured wherever possible, access to the variety of goods and products, right to be heard and to be assured that consumers' interest will receive due consideration at appropriate fora. It is a pointer that they should take a liberal approach, that too in favor of the consumers. Another principle, contra preference, is the principle where the standard form contracts are there. If there is any ambiguity, any party can point out ambiguity in standard form contracts. The benefit will go to the consumer, not to the business. This is a settled principle of law.
Yes. So another question is, he says that as to whether our law is akin to what is as per the international standards.
Because there are many deficiencies, we have amended the law after more than 36 years. If earlier it was in 86, 86, now it is there has been made in 20s. So many years have left for that purpose. Almost 14 years plus 20 years, 34 years. Our laws are not as per the standards. This is not just possible for the standards. International standards, if we cut paste from the international as per the international consumer laws, then it is not possible, because we will have to look into the conditions of every country. It depends upon the country, what are the situation, what are the level of their reading. Here the people are different. We are, some are very poor, some are above poverty line, some are high class. So law is not possible. Law will be as per the uniform standard, international standard is not possible at all. We try to make it, but what are the beneficial laws that can be taken and added to the consumer or the provisions of Indian enactments?
Thank you, sir, for sharing your knowledge, and we are indebted for the knowledge you have shared. I will ask these and request this audience, they can read section 23 of the Indian Contract Act along with the judgment of Rojonath. They will understand the unfair practice, etc. And thank you, sir, for sharing your knowledge. Thank you. Namaskar.
Recently, I have 2-3 judgments I was looking here. These are also with regard to the unfair, I will just name the few. I have also dealt with, so far as the builder buyer is concerned, in the case of Gorson versus Madhvi Sinha. This is Punjab and Punjab State Consumer Commission judgment of 21. Gorson and Sons and Madhvi Sinha. The recent Supreme Court judgments also mention about that. There are so many judgments. The one judgment is Texo Marketing Private Limited versus Tata AIG General Insurance. Another judgment is Sunil Sikka versus Mrs. Ram Prastha Promoters and Developers Private Limited. There are many other judgments also on this, where this, even the Supreme Court, unfair trade practice has been applied while interpreting the terms. Though at that point of time, no contract unfair terms were defined, the Supreme Court has applied unfair trade practice and has termed these conditions as unfair and given the benefit to the consumers.
Thank you, sir.